Hi, everyone. Hello, and welcome to our special episode of our monthly webinar series, Beyond the Field. I am your moderator, Ryan Gregg, a legislative specialist here at the North Dakota Farmers Union. Thank you for joining our webinar today. As the intent of these webinars are to provide you with the last information, with the most recent information, and have an in-depth discussion with experts. In today's topic, we'll be covering estate planning and transition, securing your legacy with Russ Wheaton, Senior Vice President, Succession and Retirement Planning, Ag Country Farm Credit Services. A quick a quick announcement. NDFU, in partnership with NDSU Extension, is hosting two special one-day succession planning workshops. The goal is to help families shape the future ownership of their family farm or ranch. Workshops will be held January 21st from 9 a.m. to 4 p.m. at the Stark Billings County Extension Office in Dickinson, and February 27th from 9 a.m. to 4 p.m. at the Lake Region State College in Devils Lake. Lunch will be provided for both. The cost, it's free to all NDFU members. Pre-registration is required to attend. A few things before I have Russ going. Everyone is on mute, but if you at any time have any questions or comments, please type them in the Q&A space. That can be found at the bottom of the toolbar or in your Zoom window. We'll have Q&A after the presentation. Also, this webinar is recorded. You can find it on YouTube, searching for North Dakota Farmers Union. We also ask that you take the exit survey after this webinar. It helps us to continue to improve these webinars. All right, about Russ. Russ is originally from the Fargo area and worked on a number of farms and ranches during his college years. This is where he found his passion for agriculture. He is an NDSU agricultural economics graduate and holds both a certified trust and fiduciary advisor certification and a chartered retirement planning counselor designation as well. Russ has been in the planning business for 28 years and has spent 18 of those 28 at Ag Country. He is a regional vice president and leads the succession and retirement division for Ag Country. In addition to his role, Russ serves from 200 to 250 farms each year, helping to design estate, retirement, and transition plans for farmers and ranchers in North Dakota, Minnesota, South Dakota, and Wisconsin. He lives with his wife, Marlis, 12 miles northwest of Waupun in North Dakota, and is proud of his 5 children and 8 grandchildren. Russ, take it away.
Thank you, Ryan. Good morning, everybody. As we go through the presentation this morning, there's slides I'm going to run through quickly. There's about 40 slides, and we've got 45 minutes, so we're going to buzz through some of them fast. If you have a question about anything I'm on or a previous slides, certainly throw it in the chat, because if you have a question about something, it's probably in the minds of somebody else. So let me get my screen shared here. Assume you can see that. Is that up there, Ryan?
Yep, I can see it, Russ.
Okay. Okay, let's get rolling. I want to introduce our team. This is me. Ryan's already talked about that. I just want you to know that we have regions that we serve. I'm Central West and North Central regions of Ag Country. I pretty much cover southeastern North Dakota. This is Aaron Sletton. Aaron is our Minnesota guy. He serves South Central and Southwest and Southeast regions of Ag Country in Minnesota. And this is Bobby Sondriel. Bobby bases out of Grand Forks and serves northwestern Minnesota and northeastern South Dakota. This is our support team. There's been a change here. Julie DeZell has now moved into a consulting role with Aaron, Bobby, and myself, and so we are in the process of replacing her. But note that all three of these support people are paralegals. And the reason for that is our department functions much more like a law firm than in a bank or an accounting firm. What we do, these are the 6 areas: estate planning, farm succession and retirement planning, transition work, entity work, also family meetings and other planning, which might involve a nursing home plan. I'm going to touch on all these as we get through the presentation. People always want to know, how do you get paid? Well, we bill by the hour. We don't sell anything. We cut that $350 per hour rate off every 10 minutes. Customers will pay for legal fees and any filing or recording fees. We don't pad them or anything when they come in. We just pass them on to our customer. So what's that $350 paying for? Paying for meetings where we will work with you, give you advice, gather the information we need to help you put together your plan. We do a lot of follow-up letters. I don't know how many it is a year. It's got to be close to 700 to 800 letters that we follow up with each year with our customers. Follow-up material might include charts, graphs, projections, those types of things. We review a lot of documents. People want to bring in their estate planning documents or their buy-sell agreements for their entity. We do a lot of document reviewing. We prepare documents. We help prepare the documents. We don't do the legal work. We can't. Our charter doesn't allow us to do legal work. So we have law firms that we work with. We have 4 law firms that do our legal work. It's paying for advice. It's paying for hand holding, and every now and then a Kleenex. And so we bill every month, and it's just that simple and just that clean. So what does it really cost when you boil this down? This is a handout we give customers sometimes to help understand in any given year, if we do some work for you. Let's turn that into a cost per bushel. I'm not going to get into all the details here, but this was a farm that we used 1,000 acres of corn at 160 bushels per acre, equated into 2 to 4 cents per bushel to do an estate plan. And so our cost per bushel is not high. And we think this is an important component to understand about where we charge. So enough about billing. Let's talk about how we work. We are team-based. We want to bring in all of the professionals. We think that's a great way to go. It allows the other professionals that work with our farm and ranch customers to understand what we're doing, what the customer's concerns are. Now, this doesn't always happen, but we always are very open to it. And so depending on what we're doing, we may bring in the accountant, we may have an insurance agent involved. We just don't know until we really get rolling into the presentation. So why is this stuff important? Okay. We think, and our financial officers here at Ag Country, as well as a lot of our tax team members, it's a risk management issue, especially when we've got a larger estate, especially when we've got a transition plan where maybe we've got a lot of grain, we've got a lot of depreciated assets. It's a risk management thing, and it can affect the bottom line, and it often does if a good plan hasn't been put in place and thoroughly vetted and thought through. It does impose more risk on that farm or ranch. This is something that we harp on almost every day. It needs to be in writing. If it's not in writing, it just doesn't exist. And what I'm getting at here is, what do you mean by what should be in writing? Well, we should have in writing what your planning intentions are. So that's where our follow-up letters really hone in on the importance of ensuring that what we talked about, what you want to have happen, what you've told your kids, is in that follow-up letter. Secondly, good documents, estate planning documents, business entity documents. A lot of times we get into meetings and we have issues with people who were promised land. Be careful about what you promise before you talk to a professional, because sometimes that promise can't be fulfilled, at least sometimes not tax-free. So we need to make sure that whatever we're doing, it's in writing. This is a kind of a golden rule in our department. So let's start with estate planning. What are we doing? What's the plan for the farm? Okay, are we transitioning the farm as an ongoing business? Or if nobody's there to take over, are we transferring assets to heirs? A will or trust, where there's a transition occurring, almost always looks much different than when there's no transition, because you're essentially taking that farm, if somebody dies, and moving it to the next generation or to a spouse. We have to make sure that we have a solid plan in place that doesn't disrupt that business. It should contain language that keeps the business going, and we're going to get into that a little bit more as we get into the slides. And I mentioned earlier, be very careful with successors buying out siblings. This is becoming a real issue. And I'm not here to impress upon everybody that we're not going to also talk to you about ensuring that your non-farming children are not taken care of. But for example, on Tuesday, we met with a 72-year-old farmer that last March had to buy out cousins. The land was in Richland County, North Dakota, and appraised at $9,400 an acre. His son is tapped out, can't afford the buyout. He had to make the buyout. And this is land that's been in the family since 1962. So he was not going to let it go. He was really still sweating this out. And that could have been avoided. It could have, or it could have been made easier with good planning. So this is what I talk about when I'm talking about risk. So when we get into estate planning, these are the documents that we look at: a revocable living trust or a will. Do they reflect the plan, the transition needs of that farm? What's the difference between a will and a trust? A will is a document that provides instructions for who's going to represent you when you die and how your assets are handled at your death. If you've got a will-based estate plan, it means the assets are still in your name, and that means then you have to open a probate. Probate is the legal process of settling the estate. At the end of probate, there's instructions from the will that says here's who gets what. A revocable living trust can own assets. Okay, so a revocable living trust is often used when we want to avoid probate and we want to keep the settlement of that estate private. Wills become public documents when you die, not before, but when you pass on, whereas a trust remains private. Where do we use trusts? Large estates, when you've got assets, especially land in multiple states, or if somebody just wants their affairs to remain private. A durable power of attorney appoints someone to represent you while you're alive to take care of your legal, business, and financial matters. Very powerful document, but it needs to be, because if you become incapacitated, we still need to pay your taxes, we still need to pay your bills, and somebody needs to be able to do that, oftentimes right away. The healthcare directive is a document that appoints someone to make medical decisions if you can't, and further has a set of instructions in the document that says, okay, if I'm terminal and I can't speak, here's what I want done. Do I want life support removed? Do I want it retained? Do I want nutrition? Do I want hydration? If I die, what happens to my body? Is it buried? Is it cremated? And do I want to be an organ donor? So this is more of a family touch kind of a document, but is also very, very important. Titling of property, I mean, it drives everything. You know, if you've got everything in joint tenancy with your spouse and you pass on, everything just automatically goes to your spouse, probate free. But here's where we get into some trouble sometimes. We don't have proper titling, and the wills are set up to do one thing where the titling doesn't match up. And so we've got to be very careful with how we title assets, especially land. And if you've got an operating entity like a corporation or an LLC, very important to know how that's owned as well. And then beneficiary designations. Anything with a beneficiary designation is not controlled by a will or a trust unless you make that will or trust a beneficiary of whatever you've got. A lot of times people will say, well, I want my life insurance to go to my non-farming children, so they want that in their will. Well, the will isn't controlling the life insurance. The beneficiary form controls it. So we have to look at all of these documents to make sure that they're set up to meet your needs and do what you want done. So why do you need a will or trust? Well, I just went over why. Determine how your assets are distributed at your death and who represents you. You'll see there we've got the will, public at death. We've got the revocable trust, private at death. If you don't have a will or a trust, Bismarck has one for you. It defaults to state law. Generally speaking, if it's your first marriage and you die without a will or trust, assets go to your spouse. If it's not your first marriage and you have children from a previous marriage, I'm just going to tell you, it gets messy really quick. And so we want to make sure that you get these documents in place Whether you have a taxable estate or not, I'm going to get into that in a second. You need a will or a trust to manage your affairs upon your passing. So is my estate taxable? So when I die, is there going to be a tax? Is my spouse going to have to write a check, or my kids going to have to write a check? Well, this gets into the federal estate tax exemption. Right now in 2025, the federal exemption per person is $13,990,000. And the reason it's such an oddball number, it started out at 11 million in 2017, or pardon me, 2018, and has been adjusted upward based on inflation since then. Next year, because of the Big Beautiful Bill Act, the estate tax exemption continues to go up. If the Big Beautiful Bill had not been passed and we had not retained the law that increased the exemption in 2018 from 5.5 million to 11 million, we would have sunsetted and gone back to 5.5 million on 1/1 of 26 with an adjustment upward for inflation. Well, the Big Beautiful Bill extended the Tax Cuts and Job Act, which brought us this large estate tax exemption. So next year we go to 15 million per person, 30 million per couple, and that will be adjusted for inflation. Now, the law says it's permanent, right? But you all know what permanent means in Congress. Till the next presidential election, that's permanent. But it takes more. It takes a lot to get these laws changed when they're made permanent. We have portability between spouses. That means if somebody dies, say with $10 million in their name, well, they've left $3,990,000 on the table. That $3,990,000 gets ported over to the surviving spouse, and it gets added to their $13,990,000. So that portability allows us to really shelter a lot of assets when somebody passes on. If the estate exceeds these exemptions, it gets taxed at 40%. That's a big tax. And when we're working with a larger farm, a larger operation, maybe with a lot of land, or maybe the family has other non-farm related assets, and we see a taxable estate, there's several things we have to do preemptively to ensure that this estate tax is either minimized or eliminated. So North Dakota and South Dakota do not have a state estate tax. They don't have an inheritance tax either. I don't know if we've got any Minnesota people on here, but if you are from Minnesota or you live in Minnesota or you know somebody that farms over there, they do have a state estate tax. The exemption is either 3 or 5 million. It's 3 million if you don't have a farming area. It's 5 million if you do. By the way, if you own assets in Minnesota and you're a North Dakota resident, like a lake home, you may still have a taxable estate in Minnesota, because Minnesota will want to know the value of your Minnesota assets. Look at the percentage that it represents of your total estate, and you may have to pay a tax. Again, it's always important to get into a conversation with somebody who's familiar with that, and there are ways of getting you out of that tax. So let's talk about a step up in basis. What is this? This means that when you pass on, depending on the asset, the basis, which is what you paid for the land, let's use land for example, or the value when you inherited that land, that's called basis. So what happens when you pass on, basis gets stepped up to the date of death value. So we've got an example here. Say you bought land for $500 an acre, and when you pass on, it's worth $7,000. The heirs receive the land at the new basis, the $7,000 per acre. So if they turn around and sell it for $7,000, there's no tax. If you were to sell that land during your life for $7,000 an acre, the difference between the $7,000 and the $500 is capital gain. That gets taxed. So you can see a step up is a big deal, especially when people are inheriting land and they maybe want to sell it. Machinery, buildings, and improvements also get a step up if you own them at your passing. So what does that mean? It means if you die fairly young, say you're in your mid-50s and you're farming and you've got a machinery line and a bin site, and you die prematurely, your spouse is going to inherit those assets depending on how they're owned, and he or she gets a step up. Assets that are gifted do not get a step up. What ends up happening when you gift assets during your life, it gets what's called carryover basis. So whatever the basis is in that land goes to the recipient of that gift. Using that same example, $500 per acre land is gifted to a child, and 10 years later, the farming parent dies. The child's basis is still $500 an acre. So there's no step up. There's an exception here with land, and that is if your land is subject to a life estate. A life estate is when you deed land to your children during your life and you retain the rights to the income. That's where it gets its name, life estate. So you've kind of bifurcated the ownership. So that land, because you've retained a right to the income, gets a step up. Okay, really important component for how we look at managing land. Here's the federal gifting rules. People always want to know what they can gift each year without telling the IRS. This year and next year, it'll be $19,000 per grantor per recipient per year. So there's no tax, no gift tax return required on the first $19,000. Each recipient can receive $38,000 as a gift from parents. So we do what's called gift splitting. And if you want to include your child's spouse, you can add another $38,000 to that. Doesn't always happen, but sometimes it becomes a very effective way to move assets tax efficiently, and we don't have to tell the IRS about it. If you go over those figures, now we're going to chew into that $13,990,000. That's your lifetime gift exemption. And so if your gift exceeds, let's just use the $38,000, then you have to subtract the amount over that 38 from the $13,990. So that's where the gift tax return comes into play. It's still tax-free, but the IRS is saying this: federal gift and estate taxes are linked. It's called a unified credit. So in other words, estate planning maximum for purposes of gifting and estate tax is $13,990. So what the service is saying, the IRS is saying, you can't give your entire estate away during your life tax-free, and then when you die, you've got another $13,990 to work with. The unified credit is kind of the IRS saying, use it how you want. This is your exemption. All right, let's talk about land. It's always a big topic. It's always one of the first things that comes up in meetings. How do I protect my land? How do I take care of my land? How should I have it set up in my estate plan? And a lot of times people will come into our meetings and go, I don't know what should I be doing? Well, equal undivided interest. That means each child has an equal ownership in every parcel of land the parent leaves them through the estate. So the question we always ask, is this a good idea? Sometimes it is, sometimes it works, sometimes we don't have a choice. It has to go equally. But think about this. Say you've got 5 kids. Now the second spouse has died, so mom and dad are now both gone. The kids inherit the land, 1/5 each. Now the ownership is fractionalized, and it becomes even more fractionalized over time. One of those children dies with 3 kids. Now their 3 children ultimately inherit that land. Now we've got 4 with a 1/5 interest and 3 with a 1/15 interest. So that's why we ask, is this a good idea? It kind of brings the non-farmer into the farmer's business, which is not always a bad thing. Sometimes it's not a good thing. But what you do is you're increasing the chances of litigation between your kids. And this is becoming a major issue for the customers we work with. When you own land together with somebody, every decision is unanimous. There is no majority. Unless that land's in a business entity, then we can do majority. But owning land together, we have to really look at that and talk about it. If we can, and if it works, we prefer having land go specific. In other words, each child gets a whole parcel. The risk here, land could leave the family, and sometimes it does. But the other matter, if you've got a successor and land goes to those that don't farm, how do we ensure that that successor has access to that land? Say if the non-farmer wants to sell it, or they don't like their brother and they want to rent it to somebody else. So we often will talk about an option or a right of refusal so that the successor farmer can both buy and rent the land from their non-farming siblings. I will tell you the courts are not, they don't like these, but most people want to do them anyway because what they want to do is send a message to their kids that aren't farming. If you want to sell, we want you to call your sibling up who is farming and offer it to them first. So let's talk about a couple of other ideas that we get into with land. Sometimes we'll look at a farmland trust where at the second passing, the land doesn't go to anybody. It goes into a trust that owns the land. And why do we do this? There's all kinds of reasons. Usually if there's a need to protect land, maybe there's a family member who's disabled, we might have an irresponsible heir, we might have somebody that just can't manage money. Maybe the children aren't in agreement, so we're not going to give them the land because we know they're going to fight. If it's in a trust, doesn't mean they're still not going to fight, but it minimizes that. We could also have the land remain in trust for say 5, 7 to 10 years. Parents don't want to burden their child that farms with having to buy land. So what do? We might keep the land in the trust for this 5 to 7, 10-year time frame with the rental income going to those that don't farm. And at the end of the trust, the child that does farm inherits the land. Okay. Now we don't always do this with every single piece. Maybe we'll leave a quarter or two to those that don't farm, and then the rest goes into this trust. Okay. That's one of the ways we might approach this. These ideas will fit each person individually. Not everybody likes this trust idea. Okay. Some love it. And so we have to introduce these ideas and see what sticks. Sometimes we'll go with a land entity. The reason we put land entities together is customers will often ask, how do I keep my land together? And then the word comes up, forever. And I always think, boy, that's a long time, forever. But they're really serious about that. So we might put it in an entity. The entity goes to the children. Maybe none of them farm. Maybe one of them farms. But what this entity does is it puts a rule book in place about who can own the entity, how the entity is valued, how somebody gets bought out. And if we do have a farmer in there, oftentimes we're going to want to make sure that farmer has the ability to control the entity. All right, switch to machinery. Usually in the estate plan, this is left to the farming child. That is definitely the trend. I mentioned the step up, and sometimes what we'll do is the family wants to figure out how to kind of equalize the estate. They're really concerned about the land, so it might go to all the kids with the farmer given an option to purchase it and the proceeds then distributed to all the kids. That doesn't happen as much as it used to. How about the farm site? If there's infrastructure there, in other words, it's where the farm is, and that's how most of them are set up, typically left to the farming child. Sometimes if the home is separated, it's maybe down the road or across the road or something like that. That residence, if the successor already has an established residence, sometimes it just goes to the non-farmers who can either buy it from the estate or it just gets sold. All right, this is an issue. I don't know that we see it a lot anymore, but we still see it where the successors put bins up or they've contributed to enhancing the grain handling system or helped pay for the shop. But the land underneath, they don't own. That's a problem, especially when somebody passes on. So if something happens to both persons and that farm site is still in mom and dad's name or the parents, who owns that improvement on top of that land if both parents are gone? Whatever the will says. Okay, so if the will says my farm site equally to my children, it goes equally to them. And so we've got to be very careful about who owns the land under the farm site. So nursing home, let's talk about this because this is always an issue. When I first started working at Ag Country 18 years ago, we still lived in town. I knew as much about the nursing home as when I drove by it. It just wasn't an issue. But now with somebody at a skill level of care, anywhere from 11 to 12 to $15,000 a month, they're getting high levels of care. So people want to look at this, they want to talk about it. There's two points of view we see. There's some that I want to protect my assets. And then there are those that say, I'll pay my own way, even if I have to sell. Both are right. There's no right or wrong. Most want some level of protection, especially for their land. Is this a big issue? I mean, do the statistics bear out that we should really get in front of this? It's so wide and varied. I mean, I've read so much on this, and I've seen, the data would suggest that 1 out of 3 will need a nursing home stay, and I've seen others where it's higher than that. So it depends on who's writing it. The average stay, 2 to 3 years. Boy, that's all over the board. A cognitive disorder could be 8, 9, 10 years. But we just don't know. So most people want to get out in front of this. If you don't have adequate income and assets to pay for your care, then you apply for medical assistance. Any assets that's gifted has a 5-year look back. And this is where we get into the land. Land most often is what people don't want to have to sell to pay for a nursing home. So we gift land to the kids subject to a life estate. That's how we do it with most of our customers, and get that 5-year look back clock started. Because if you go into a nursing home prior to that 5-year look back being met, that land is still considered to be available and might have to be sold. Retirement planning. This is about cash flow and tax planning. It's almost always. And we always want to know, where's this income coming from? Was the farm profitable? What's the family living? How much debt? The big killer with retirement planning is debt. And that's the one that we really got to work around. And this is where we might want that loan officer in the meeting. But here are the places we look for income. You'll see that installment sale issue there. That's the depreciated assets. You've got to be very careful with depreciated assets if you sell them over time, like you might sell land over time on a contract. The tax treatment is completely different. When you sell a depreciated asset over time, you're subject to the installment sale tax rules. So what does that mean? Say you've got a 10-year agreement to sell machinery. Okay. So what ends up happening in year one, the first check is written, the whole contract is taxable in year one. So you've got 10 years of taxes and 1 year of payments. And this is why we don't do that. We get into a whole different approach to machinery. We usually use a lease. So when we're working with someone, we're looking at these successors. We do the blood test. Now, this isn't with needles. This is to see how committed our successor is and their spouse. Almost always, they're pretty dang committed. And so that's generally not an issue because we already know they want to farm and they're going to take over. Are the management skills being developed? Okay. Do the successors have an owner or employees mentality? This is huge. It's a whole different dynamic if somebody does not possess that owner's mentality. They have to be a business person. And senior, are you a mentor or meddler? Most of our seniors are terrific mentors. We have such great farmers in this region that just really do a great job teaching and mentoring their successor. Sometimes outside off-farm experience is a big plus. There's been a lot of studies done that says you should work off the farm for 2, 3, 4 years and then come back. We support that. Sometimes that's a really good way to understand how to get along with people. And of course, will the size and scale of the farm support everybody? These are some ideas for machinery bins and grain handling. I won't go through each one line by line. I do want to look at the 4th bullet point. This is a very popular choice. It's called a tax or an operating lease, and this is where we avoid those installment sales. We use these for machinery and building sites. It's a lease. It's a true lease where the parents would retain ownership, say in the machinery, and then the successor leases the machinery from the parents over a 5, 8, 10-year time frame. It avoids the installment sale. It's a great way to provide income to the parents for their retirement, but it puts the successor on the path to ownership, and they control and manage that machinery. Extremely popular. And again, there's lots of other options in here. And you see, I've got putting assets in a corporation. There are a lot of planners that really go this direction. Be careful. If it goes into a corporation and someday you want to unwind that corp, you're not going to do it tax-free. But for the large multi-owner farms, we always bring this up and just vet this out and see if this is something that works. Land, usually the last asset to transfer, if at all. I mean, this is your parents' retirement plan or your retirement plan. We need to make sure we're designing anything so that that successor has control. Giving up control for land is never a good idea if you've got a successor. We will be very honest with you if you come in and you want to do something where a farmer's going to lose control and just ask, is this really what you want? Sometimes we might ask the question, did you get treated this way? And usually not. And so we're always a little puzzled as to why you want to give up control. How about a business entity? Okay. Let's look at this. What's gained and what's lost. Our position on business entities, it has to make something better. Tax control, transition, liability protection, something that is enhanced by a corporation or a partnership or an LLC. Maybe it makes administration easier. Rather than everybody farming on their own, we put a partnership together, one checkbook, one set of books. It just gets cleaner and easier. But when you have an entity, you're kind of like married, right? I mean, you have to do everything in unison. You have to communicate well. We have to make sure that the people that want to form this entity have the moxie to run it. Pay for business-related expenses out of the checkbook and not pay for personal stuff out of the entity checkbook. So we always analyze this too. We just want to know what's gained and what's lost. So let's talk about family meetings. This is where we learn a lot about whether people like each other or not. And usually they go well. I mean, I'm not here to tell you that everybody fights. That is not the case. But what is discussed? Well, we should talk about what the parents want done. If it's the estate plan, why? Why did mom and dad design this plan? Why have they got my brother who farms getting all of these assets and I'm not getting very much? Okay, we need to have that open discussion. When do you have them? Well, typically we would recommend once we've got a solid idea on the plan, where the estate plan, the transition plan, or both. Probably when we know what we're doing or after documents are signed. Who should attend? Let's talk about our children's spouses. Should they attend? And I can guarantee you right now, if I saw this audience in person, there's going to be some doing this and some doing that. It depends. We have to know the family dynamics and understand, is it a good idea to have your children's spouses in? Typically it is, because your children are going to go home and tell their spouse what we talked about. And sometimes they don't get it right. Well, we also understand there are dynamics out there where it just isn't a good idea. And we have to respect that. Communication is probably my favorite topic to bring up. We'll get I guess a little flippant here with those first 4 bullet points. It's the biggest reason you succeed or you fail. It's the biggest reason there's disagreements, the biggest reason there's mediation, and ultimately, it's the biggest reason to avoid litigation. Okay, so if your plan unfolds successfully, typically what we see is there's good communication going on. People are working together, they're talking, they're discussing, they're respectful when they communicate, and it just becomes a really fun experience. So we've got verbal versus nonverbal. Be careful what you do, because if you say you're going to transition the farm and you're still 70 and you're farming all the acres, you're not transitioning. Okay? You're still farming. Don't make promises you can't keep. I mentioned this earlier. Talk to professionals before you promise something. Don't make your farm your Las Vegas. Okay, what happens on the farm stays on the farm, or what happens in the shop stays in the shop, and the spouse never knows what's going on. So lack of communication always invites assumptions. Assumptions morph into someone's reality, which ultimately becomes their fact. So make it clear what you're doing and always tell folks why you're doing things. So some ending thoughts. Don't delay planning. Get into this early. Early might be early to mid 50s. If you've got a successor, just get in and talk to us or somebody that knows what they're doing in this world about what are the tax implications if I want to get out? How do I take care of my debt? How do I move my machinery? What should I do with my land? What should my will or trust look like? That takes time. That really takes time. You'll get this advice somewhere. And whether it's from a transactional based advisor or somebody that, like us, we just charge an hourly rate. If you feel comfortable with them and they give you good advice, work with them. Transactional based advisors are usually going to want to sell you something like maybe life insurance or a pension. If it works and it fits your plan, go for it. A lot of people don't like that though. They want to feel as though they're getting advice from somebody who's very objective and is not sitting over there thinking about what they can sell them. Most farmers we work with, when we have our first meeting, they really don't know how to get started. That's why you got to get started early, because time's your friend. Communicate early and often. Grunts only belong in the hog barn. Okay. And we want to make sure that, as I mentioned earlier, we can't impress upon you the importance of good communication. And remember, if you don't plan for the future, you're probably going to compete either now or at some time with a farm that is planning for the future. So, okay, Ryan, let's see if there's some questions.
All righty. Thank you, Russ. And we do have a few questions. First question, which is just a housekeeping question. Yes, this is recorded. So if you missed the first half of the webinar, this will be available on our YouTube channel after this is all over. Now then, to the first question from Julian Rancine. Does the estate tax exemption apply to inheritance from parents?
Yes.
Yes. Okay.
Most often, that's where it's coming from.
Okay. And then another quick question is, for the estate tax exemption, does it only apply for ag land or does it apply to other types of property?
Every asset.
Every asset?
Anything that you own in your name when you pass on is includable in that 13,990 or that 15 million, including life insurance that might be in your name. So if you've got a large taxable estate and you've got life insurance on top of it, we really need to analyze if we need to do something with that life insurance and get it out of your name.
Okay. And then we have another question. So the question is, does the step-up in basis apply to shares in corporation or co-ops as well?
Would apply to both.
It would apply to both? Okay. If anyone else has any questions, feel free to put them in the Q&A. I have one question for you, Russ. How do I know what is the best trust option to manage my assets during my life and distribution after death?
You said best trust option?
A best trust option.
Well, there are two types of trusts, Ryan. There's revocable and irrevocable. Irrevocable, you can't change that. When we have an irrevocable trust, there's a solid reason to put that in place. I'm not a big fan of irrevocable trust because I've been through too many situations where an irrevocable trust is drafted and 8, 10, 12 years later, some unforeseen event comes along and they want to do something different with the trust and they can't. Now you can bust an irrevocable trust, but it's going to take either a judge to approve that or your family to approve that. So the other type of trust is revocable, and that's where we do 95% of our trust work. Trust versus will, Ryan, is often a personal choice. I like trust. My wife and I have a trust. We have property in 2 states, and that's why, because I don't want probate in South Dakota and North Dakota. But it keeps the estate private. The trust also has provisions oftentimes for disability. if I'm disabled and I can't farm anymore, I want so-and-so to farm my land. Might not be a child, might be a neighbor, because you don't have a child that farms. So trusts are really useful instruments, not only after you pass to avoid probate and keep your estate private, but maybe you want something in there during your life, especially if you've got young kids. You've got minors. My favorite saying is it a good idea for an 18-year-old and $4 million of assets to meet at the same time? Probably not. So it's really case specific, Ryan, and we're not going to sit over there and say the only instrument you need is a trust. That's not how we do things. We'll look at your personal situation and take it from there.
So there is another question, but I just want to follow up on what you just said quickly. Um, so you talked about the cons of an irrevocable trust. What are the pros of an irrevocable trust, and what are the cons of a revocable trust? If you can just.
Sure, the pros are private settlement. If you've got it funded with assets, if you've got assets owned by the trust, no probate. We have disability provisions. A trust can remain in place after you're gone to take care of kids or grandkids. So those are the pros. The cons, it costs more. Costs more to set up. You have to have a trustee. Almost always what we see when there's a trust, the trustee is a manager, by the way. They manage pursuant to the terms of the trust. Usually that's going to be a child or children. The potential downside could be is that they bring a bank in. The bank's going to charge them. And sometimes that's our only option, and sometimes that's viewed as a downside, Ryan, but typically a trust has significantly more upside than downside.
Gotcha. So there is a question. For power of attorney, does that need to be drawn up in the state that the person is getting it in? For example, say a parent lives in another state or a child lives in another state. Does that need to be drawn up there, or how does that work?
Where they're a resident.
Or they're a resident?
They're
Okay.
a resident. Yep.
Okay. Um, that was, I'll just wait a minute to see if there's any other questions. Oh, we got another one. Okay. Do you recommend that a trust should sunset at some point and the land be distributed?
Yes. Yes. Remember that comment I mentioned earlier on. I want my land to stay together forever. And that's a long, long time. But for example, North Dakota, there is a statute. It's called a Rule Against Perpetuities, and it states that a trust at some point has to end. So
Gotcha.
by law in North Dakota, you can't have it go on forever. Typically, it's about 90 years. There's a statutory formula. I won't get into all the details, but when I run the numbers, typically it's somewhere around 90 years. Okay. Now there are states like South Dakota, they have dynasty trust rules where a trust can stay together for a long, long time, much longer than that. But they really should end. They should get, whatever's in that trust, and typically its land should be distributed. But sometimes there are very valid reasons, Ryan, for a trust to stay together after both parents are gone. And we have to address those reasons. And sometimes it's in everybody's best interest that that trust stays together after both parents are gone for whatever period of time we think is the right period of time.
Okay, perfect. So sorry, just a quick follow-up on the question. I guess something was quite clear. So for the person getting the power of attorney, does it need to be, where is the person getting the power of attorney? Oh, sorry, I'm a bit confused by this question. I think people just want to clarify. Does the power of attorney need to be written in the state that the land is getting received, or in the state in which the person resides?
State the person resides. We have powers of attorney we set up, and it's called the attorney in fact or the agent. Each lawyer has a different phraseology for it. I mean, you can have your attorney in fact live in another state, and we often see that. And your POA doesn't necessarily need to be where your land is either. I mean, we have people with land in several other states. I have one in particular. He has land in 4 states.
Hmm.
He's a North Dakota resident. and his POA is a spouse, North Dakota. So it doesn't matter really where the assets are located.
Perfect. Um, I'm looking for any other questions. I'll give it a minute. I got a quick question, and you may have mentioned this. Should people consider gifting prior to death?
Yeah, again, very case specific, Ryan. Generally speaking, it depends on the size and scale of the estate. That's one place where we're starting. If it's a large estate, we may recommend some gifting. Um, when we had this Tax Cuts and Job Act was supposed to sunset the end of this year, we had several large farms set up in land partnerships to gift that partnership to avoid estate tax. But a lot of times gifting is done as a transition tool to move machinery.
Mhm.
The life estate's considered a gift, asset protection strategy for a nursing home or a way to get equity into a successor's name. Um, again, very, very case specific. There are customers we work with that are very generous and they want to see their children enjoy their life's work while they're alive. And conversely, there are those that not giving a penny away. So we really have to look at the case. But a large taxable estate is where we really start to emphasize some degree of gifting.
Okay. So we have another question, and I'm gonna build on this question a little bit. The person wants to know, how do you recommend protecting property for a single person with no children? And I would also add to give to somebody who isn't maybe related to you. How would that work?
Yeah, so protection, I'm assuming it's a nursing home. I'm
Mhm.
just going to jump on because when people come into a meeting with us and we've got our questionnaire and says we want to protect our assets, we always ask, well, protect from what? Is it a divorce? Is it a child that is irresponsible? So in this case, Ryan, to protect, I'm going to assume it's land.
Mhm.
You don't have any kids and you're single. Now we have a case for an irrevocable trust. Okay. Because there aren't any kids to put, give the land to, we can't use a life estate, or usually we don't. And so we have that irrevocable trust set up. We put the land in there. After 5 years, that land is protected, assuming the land is not subject to a mortgage. Okay. And then whatever that trust says to do with that land when that person passes on, that's what happens.
Gotcha. Okay, interesting. Um, so another question is, there's two questions. I'm going to skip over the one and come back to that. How costly is probate when there is no will or trust?
Oh boy, it depends on, I keep saying it depends because it really does.
That
Uh,
sounds like that.
but it's going to cost you more. There's going to be a little more work that the law firms and the probate paralegals need to do to get the estate going. That the courts have to appoint a personal representative. If you've got a second marriage and children from a previous marriage, it's going to be more,
Gotcha.
definitely more.
And so I think this is a very good question to end on. How long does this process take for the estate plan? Like,
Yeah,
I think that's a very good question.
yeah. If we've got a fairly complex farm, it's going to be 6, 8, 9 months, 12
Got-
months. Um, if it's fairly simple, we could probably get it done in 2 or 3 meetings, which is about 6 months, and maybe quicker. Um, what takes time in our world is transition. That could be 5 to 10 years, and people go, "Why does it take 10 years?" Well, if you've got a machinery lease that goes for 10 years, your transition is 10 years long because you're going to own that machinery till that successor makes that final payment and then they own it. So much shorter for an estate plan. In the middle is retirement planning. We like 3 to 5 years. We don't always get that. And then the transition plan is probably going to be a 5 to 10 year process. Sometimes it's shorter if we've got well-organized farms and they know what they want. We can get through that in 3 years.
Okay. So we got one question at the last minute. You know, how often should someone review a trust? Say someone set up a trust, 10, 15 years ago. How regularly should they review that or just keep
I
that?
should I should have touched on it. That is a very good question. If you have a successor, you should review your will or trust every 3 to 5 years. If you don't, every 5 to 7. Okay.
Mm.
Always review if there's a major lifestyle change. Somebody dies, somebody divorces, you inherit assets, somebody becomes disabled. Those are triggering events that you really should get in and see someone about your existing will or trust. It may not need to be changed, but there may also need to be significant changes. Okay.
Awesome. Well, thank you. Well, thank you, Russ, for your time.
Welcome.
If anyone has any questions, please, Russ, are you available if they can reach out to you?
Yep. My phone number and email address are on the last page of the slide deck, Ryan, and you're certainly welcome to share that with anybody that wants it.
Yeah.
If you got other questions or want to talk about something more personal on a private nature, just give me a call or shoot me an email.
Perfect. Again, thank you again. This recording can be found on the NDFU YouTube channel, and be on the lookout for the next NDFU webinar, which is on November 19th, which is about the One Big Beautiful Bill tax provisions. So again, thank you all. Have a great day.